Welcome to today's lesson on decisional competence in criminal law, which is a critical part of ensuring fairness and justice in the legal process. We'll be focusing on understanding the different types of competence, the balance between state intervention and personal autonomy, and we'll explore a case study of Goddins versus Moran to illustrate these concepts in action. Competence in criminal law is about making sure that a defendant is capable of participating meaningfully in their defense. There are two major types. The first being adjudicative competence. This is about being mentally fit to stand trial and understanding the charges and being able to work with your lawyer. Then there's decisional competence. This focuses on a person's ability to make specific legal decisions, like whether to plead guilty or waive their right to a lawyer. This distinction is important because a person might be able to stand trial, but not have the capacity to make certain legal decisions. Here we explore two important concepts. Parens patriae. This is the legal idea that the state can step in and make decisions for people who cannot care for themselves. It's like the state is acting as a parent. And then there is autonomy. In contrast, modern legal principles stress the importance of respecting individual autonomy. The idea that people should have the right to make decisions for themselves unless they are incapable of doing so. So the state can only intervene if a person is proven unable to make a particular decision. This balance is key to protecting human dignity while also providing care. This slide covers common situations in criminal law where decisional competence is needed. For example, a person must be competent to stand trial. A person must be competent to consent to search, waive the right to self-incrimination, or enter a guilty plea. They also need competence to make more complex decisions, like waiving the right to a lawyer or refusing an insanity defense. Ensuring decisional competence in these situations is crucial because these choices can drastically change the outcome of a case. And fairness in the legal process depends on the defendant making informed decisions. So let's look at the Goddins versus Moran case. Moran was involved in multiple murders, and after his arrest, he attempted suicide. He was then evaluated by psychiatrists and found competent to stand trial despite his mental health issues. In this case, the focus was on whether he had the decisional competence to represent himself in court, waive his right to counsel, and plead guilty. It highlights the complexities of assessing competence, especially when mental health issues are involved. The legal system must decide whether someone is competent to make crucial decisions. In Moran's case, we look at competence to plead guilty. Moran was depressed and taking medication, which could affect his decision making. There was also competence to waive counsel. The judge asked basic questions, but did not dig deeper into whether Moran was fully aware of the risk involved in representing himself in court. Moran chose not to present any mitigating evidence, raising questions about his competence to make strategic legal decisions. This shows how tricky it can be to assess decisional competence, especially when a defendant's mental state is in question. Broader legal implications. Here we reflect on the implications of decisional competence. A person might be found competent to stand trial, but incompetent to make other decisions, like waiving their right to a lawyer. Should a finding of incompetence in one area, like waiving counsel, automatically mean they're incompetent in others, like entering a plea? These questions are important because they affect the fairness of the trial. The legal system must carefully evaluate each type of competence to ensure that justice is served. In conclusion, decisional competence is a crucial aspect of the legal process, but is often overlooked. The Gardens versus Moran case highlights the importance of evaluating a defendant's ability to make informed decisions, especially in high stakes situations like self representation or waiving key rights. Understanding these issues helps ensure that the defendant's rights are protected and that the justice system is carried out fairly. So let's begin understanding how the majority of criminal cases in the US are resolved. More than 90% of cases never go to trial. Instead, they're resolved through guilty pleas. When a defendant pleads guilty, they're admitting guilt without having a full trial. However, to ensure fairness, the law requires that the plea is knowing, intelligent, and voluntary. This means the defendant must fully understand the plea's consequences and the plea must be made freely and without coercion. Today, we'll explore what this means in more detail. When we say a guilty plea must be knowing, we're talking about three specific things. The defendant must understand before they can plead guilty. First, they need to know the nature of the charge they are pleading to, what they are accused of. Second, they must understand the penalties they will face if they plead guilty. And lastly, they need to know which constitutional rights they are giving up, such as the right to remain silent, the right to stand by jury, and the right to confront witnesses. These are crucial elements that make the plea knowing. Now let's talk about competency. A person needs to be mentally competent to plead guilty. The Supreme Court in the Moran versus Gardens case ruled that the standards of being competent to plead guilty is the same as the standards for being competent to stand trial. This means if someone is competent enough to go to trial, they are also competent enough to plead guilty. Earlier courts like Sling and Iman believed pleading guilty should require a higher level of competency because it involves giving up important constitutional rights. However, the Supreme Court decided that both situations require the same level of understanding. Let's move on to what it means to plead to be voluntary. Many guilty pleas happen through plea bargaining, where the defendant agrees to plead guilty in exchange for a lesser charge or sentence. The Supreme Court has ruled that as long as the plea is made rationally and without force or coercion, it is considered voluntary. Even if the defendant pleads guilty to avoid a worse outcome like a longer sentence. So, even if a defendant feels pressure, as long as they make a rational choice, the plea is considered voluntary. Defense attorneys play a critical role in this process. It's their job to explain to the defendant what pleading guilty means. This includes discussing the charges, the penalties, and the right the defendants will be giving up. The court assumes that the defense attorneys has helped the defendant make an informed decision. During the plea hearing, the judge will ask the defendant a series of questions to confirm that they understand what's happening and that their attorney has explained everything to them. Sometimes mental health plays a big role in determining whether a defendant is competent to plead guilty. Mental health professionals may assess the defendant's ability to understand the legal process and make informed decisions. However, even if a defendant has some mental health issues, it's ultimately up to the judge to decide whether the plea is valid. If the judge finds that the defendant's mental condition has impaired their ability to make a rational choice, the plea might not be accepted. So, the court needs to evaluate both the defendant's competence and whether their plea is truly voluntary. Finally, let's wrap up with some questions for discussion. First, do you think that pleading guilty should require a higher level of competence than going to trial, since it involves giving up important rights? Or what are your thoughts on plea bargaining? Does it unfairly pressure defendants to plead guilty to avoid harsher penalties? And lastly, what safeguards should be in place to ensure defendants are making truly informed and voluntary decisions when they plead guilty? These are important questions as we think about fairness in the justice system.